Okay, let's proceed. Okay, let's go to Article 1493. Okay, what is the effect of the loss of a thing at the time of sale? Again, if the thing is entirely lost at the time of the perfection, the contract is inexistent and void because there is no object. If the thing is only partially lost, the vendee may elect between withdrawing from the contract because it's already partially lost and demanding the remaining part, or paying its proportionate price lang. When a thing is considered when does a thing considered lost, its existence is unknown or it cannot be recovered. Okay, so let's look at an example or a scenario. S sold his car to B. Unknown to both of them, the car has been totally destroyed before they agreed on the sale. In this case, there is no valid contract for the sale of lack of object. S as owner bears the loss and B does not have to pay the price. Bakit siya magbabayad? Wala naman siyang binili in essence. Okay, so that's when the thing is entirely lost. Another example. If the car is sold, okay, car is sold, is only partially destroyed, there still remains of the object kasi nga partially destroyed. However, since it is not in the character or in the condition contemplated by the parties, the buyer may withdraw from the contract or demand the delivery of the car paying its proportionate price. So, dalawa option niya dito. Pwedeng sabihin niya, "Oops, sorry, hindi ko na gusto yan. Hindi yan yung pinag-usapan nating bibilhin ko since it's partially damaged. I can no longer proceed with the contract of sale." Or the other way is, "Okay, bigay mo sa akin yung car, pero I will no longer pay the amount we agreed. It should be way lower because it's been partially destroyed." Those are the options. Okay? So, in Article 1494, it's still on the effects of loss in case of specific goods. It applies only to sales of goods. That is, the object of the sale consists of a mass of specific goods. So, if the sale is divisible, a contract is divisible when its consideration is made up of several parts, and the sale is indivisible when the consideration is entire and single. The object may be considered as specific thing. Okay, so let's look at another scenario. Oops. Mhm. Okay, sorry. Okay, so example, suppose the subject matter sold was 100 kavans of rice in the warehouse of S at 1,000 per kavan, or a total of 100,000 pesos. If 60 kavans of rice were lost, B may, at his option, withdraw from the contract without the obligation to pay for the rice or demand the delivery of the kavans, but binding him to pay the agreed price of the. What's happening to my slides? Sorry guys. Oops. Na-distort yung format niya. Okay. Okay. So, again, suppose the subject matter sold was 100 kavans of rice in the warehouse of S at 1,000 pesos per kavan or for a total price of 100,000. If 60 kavans of rice were lost, B may, at his option, withdraw from the contract without obligation to pay for the rice or demand the delivery of the 40 kavans, but binding him to pay the agreed price thereof, which is only 40,000. If the contract is indivisible, that is, the 100 kavans of rice were sold for 100,000, fixed without consideration of the number of kavans, B should be made to pay only the proportionate price of 40 kavans, which is also 40,000 pesos. Okay. So what are the obligations? This is important. Obligations of the seller or vendor. So principal obligations of the vendor under Article 1495. 1. To transfer the ownership. 2. To deliver the thing. 3. To warrant against eviction and hidden defects. 4. To take care of the thing pending delivery with proper diligence. And 5. To pay the expenses of the execution and registration of the deed of sale unless there is a stipulation to the contrary for the expenses for the execution and the registration of the deed of sale unless there is a stipulation to the contrary. So essentially, you're just going to give everything and also take care of the thing sold as pending delivery. What are the obligations? Okay, to transfer ownership and deliver. So ownership by vendor at the time of perfection of the contract is not essential. Okay, you do not have to own the thing at the time the contract of sale is perfected. The vendor need not be the owner of the thing at the time of the perfection of the contract. It is sufficient that he has a right to transfer the ownership thereof at the time it is delivered. Okay, basta nung dineliver niya, siya ang may karapatang mag-transfer ng ownership. One who sells something he does not yet own is bound by the sale when he acquires it later. So, hindi mo rin pwedeng sabihin, ay, sorry, atras ako sa sale kasi hindi ko pala nabili yung kailangan kong ibenta sa'yo. No. Okay? One who sells something he does not yet own is bound by the sale when he acquires it later. So, that's in the case of Bukton versus Cabal. When a property belonging to a person is unlawfully taken by another, the former has a right of action against the latter for the recovery of the property. Such right may be transferred by the sale or assignment of the property, and the transferee can maintain such action against the wrongdoer. It's in the case of heirs of Q. Seraspe versus Court of Appeals and Waite versus Peterson. So let's look at the case. Goods which seller warranted as already on the way did not arrive. Okay, so let's look at the facts. B. Vendee gave his consent to the purchase and sale of certain goods on the assertion of S, the vendor, stated in the contract that the goods were already on the way, the goods did not arrive. So sinabi ni B, no? B, Vendee gave his consent to the purchase. So sabi na ni buyer, bili siya, di ba? And sale of certain goods on the assertion of S, vendor, stated in the contract that the goods were already on the way. Dahil nga, sinabi naman na ni S, yung nagbebenta, on the way na daw, in transit na yung binibenta. But the goods did not arrive. Issue, has S the right to, or would S have the right to demand from B the payment of the price? Answer, no. The assertion made by S is a warranty, which is under Article 1545 and 1546, the non-fulfillment of which constitutes a breach of contract, okay, and deprives him the right to demand of B the payment of the price of the sale. Having elected to bind himself in that way, S as vendor is responsible, even if the prompt transportation of the goods does not depend upon him, but upon the importers. For he who contracts and assumes an obligation is presumed to know the circumstances under which it can be complied with. So, in this case, si S, hindi siya pwedeng mag-demand kay B, yung buyer, na magbayad ka na because the goods never arrived. Okay? So, you should have made sure that the goods will arrive. Okay? So, you cannot demand payment from B. Hindi mo pwedeng sabihin na, oh, nag-agree na tayo. Sinabi mo, babili ka. So, even if nag-agree si B, okay, it's clear in this case that nag-agree si B, but because the goods never arrived, S is at fault and is in breach of the contract of sale. What would that pay for something that hasn't arrived yet? E sinabi mo pa naman, it's already on the way. Eh, hindi naman siya dumating. Okay? So, that's the case. About obligation to transfer ownership and deliver, and item number 2, transfer not essential to perfection of the contract. Biglang sabihin yan, doesn't necessarily mean dahil hindi mo pa na-deliver, hindi pa na-perfect yung contract of sale. No. The transfer of ownership and the delivery of the things sold are not essential to the perfection of the contract. But, if the seller does not deliver at the time stipulated, the buyer may ask for the rescission of the contract or fulfillment with the right to damages in either cases. In either of those cases. So, pwede niyang ipa-rescind yung contract or pwede niya pong ipa-fulfill yung contract. Kung ipa-rescind, meaning cancel na yung sale, ayoko na, di ko na bibilhin. Diba? Or, the other one is to ask the seller to fulfill the contract, but I will sue for damages. Okay? That's under Article 1191. Okay, is there no obligation to make delivery during period of redemption? So the purchaser in execution sales, however, is not entitled to immediate possession of the property sold. In other words, the debtor is not obliged to make delivery during the period of redemption. In all cases of extrajudicial foreclosure sale, the mortgagor may redeem the real property sold within 1 year from the date of the registration of the sale. Okay, and then there's also a right of vendee to transfer of certificate of title. In a sale of registered land, the vendee has a right to receive and the vendor the corresponding obligation to transfer to him not only the possession and deployment of the land, but also the certificate of title. Dapat pa sa iyong titulo ng lupa. Right of the buyer to recover the price paid. The right of a party to recover the amount given as a consideration has been passed upon in a case where it was held that whenever money is paid upon the representation of the receiver that he has either a certain title in property transferred in consideration of the payment or a certain authority to receive the money paid, when in fact he has no such title or authority, then although there be no fraud or intentional misrepresentation on his part, yet there is no consideration for the payment. So again, the right of the buyer to recover the price paid. So the right of the party to recover the amount given was a consideration has been passed upon in a case where it was held that kung nagbayad siya, di ba? Tapos, sabi niya, there is a property transferred, consideration of the payment. Kung hindi natuloy, then it has to be repaid. Okay? Recover the price paid. What are the obligations of the vendor? So, 1, actual or real delivery, constructive or legal delivery, or delivery in any other manner signifying an agreement. Okay, so another um, item as a obligation of the vendor is delivery. So you can choose. It could happen in either of these cases: actual or real delivery, constructive or legal delivery, or by delivery in any other manner signifying an agreement. Okay, so let's look at another illustrative case. S agreed to sell 170 kavans of rice to B at the price of 37.25 per kavan. Delivery to be made at T store. After the goods were unloaded at T store, S's driver, okay, tried to collect the purchase price from T, as B was nowhere to be found. But T refused, stating that he had purchased the goods from B at 33 per kavan, and the price had already been paid to him. So, this is a simple case of swindling perpetrated by B at the expense of S and T. However, 3 days after delivery, T was repaid by B. Issue: is T duty bound to return the 170 kavans of rice to S or to pay its value? Kasi dito, una, nagbenta si B kay T at the price of 33 for the 170 kavans of rice. Wala pa sa kanya yung rice. Binili niya ngayon kay S. Pero ang pagbili niya 37.25. Diba? So is T duty bound to return the 170 kavans of rice to S or to pay its value? Yes. Sale between B and T voluntarily rescinded by the repayment. So dahil nagbayad si B kay T, di ba? There was a perfected sale. Ownership of the rice too was transferred to the vendee B upon its delivery at the place of the stipulated. And pursuant to Articles 1477 and 1496, okay, at the very least, B had a rescissible title to the goods for non-payment of the purchase price, but which had not been rescinded at the time of the sale to T. Having been repaid the purchase price by B, the sale as between B and T had been voluntarily rescinded, and T was thereby divested of any claim to the rice. Technically, therefore, he should return the rice to B. Kasi nga, sinuli ni B yung pera after 3 days. After the delivery, T was repaid by B. So siguro sinuli ni B kasi lulugi siya, di ba? 33 lang yung bili ni T sa kanya. Pero 37.25 ang kuha niya kay S. So lugi siya. Okay? So by 4.25 per kavan. Okay. So number 2, rule against unjust enrichment applies. Since the rice had not been returned to B, who was ready to return the rice to S, it follows that T should return the rice to S. It cannot be allowed to unjustly enrich himself at the expense of another by holding on to property no longer belonging to him. In law and in equity, therefore, S is entitled to recover the rice or the value thereof since he was not paid for the price therefore. Yan yung sinasabi natin dito, the right to recover. Okay. Okay. So, kinds of delivery or tradition. Real takes place by the delivery or transfer of a thing from hand to hand. Okay, movable or possessory acts by the vendee. Constructive exists when delivery of movable and immovable things is not actual or material but represented by other signs or indicative thereof. Okay, symbolic delivery. The parties make use of a token symbol to represent the thing delivered. The buyer has control over goods but no delivery made. Okay, legal, as when the sale is made through a public instrument and the execution thereof shall be equivalent to the delivery, which Um, ito yan. So, okay. So, as when the sale is made through a public instrument, the execution thereof shall be equivalent to the delivery of the thing, which is the object of the contract. From the deed, the contrary does not appear or is not clearly inferred. Okay. Symbolic tradition with respect to movable property is delivery may also be made by the delivery of the keys of the place or depository where it is stored or kept. So example, A sold his car to B. A handed over the keys to B to symbolize that he is handing over the car. Hindi niya siguro bubuhatin yung car tapos ibibigay kay B. Di ba? So, kung binenta niya na yung car, ang symbolic is to just give the keys, okay, to the buyer. Ways of effecting constructive delivery. It may be effected in any of the following ways. By execution of a public instrument, pumirma ka sa kontrata, like deed of absolute sale, or by symbolical traditional, okay, or by traditio longa, longa mano, breve mano, constitutum possessorium, or quasi-tradition. Okay. Contrary may be stipulated. The parties may stipulate that ownership in the thing shall pass to the buyer only after he has fully paid the price or fulfilled conditions. So it can be put in the contract. Okay, so tradition or concept of tradition or delivery is a derivative mode of acquiring ownership by virtue of which one who has the right and intention to alienate a corporeal thing transmits it by virtue of a just little to one who accepts the same. Okay. The importance of tradition, delivery of the thing to enable the buyer to enjoy and make use of the property purchased. After delivery, the risk of loss of the thing is borne by the buyer. Importante siya na it happens, okay? Especially for movable personal property. So transfer of ownership emphasizes the necessity of tradition for the transfer of ownership of the thing sold. Our law does not admit the doctrine of transfer of property by mere consent. No, walang ganon. The ownership over it is not transferred by contract merely, but by delivery, actual or constructive. The critical factor in all the different modes of effecting delivery, which gives legal effect to the act, is the actual intention of the creditor to deliver and its acceptance by the vendee. Okay? Contracts only constitute titles or rights to the transfer or acquisition of ownership, while delivery or tradition is the method of accomplishing the same, the title and method of acquiring it being different in our law. But there is no delivery as to transfer ownership where the vendee takes possession of the personal property subject matter of the contract of sale by stealing the same while in the custody of the vendor or his agent. Okay? It is during the delivery that the law requires the seller to have the right to transfer ownership of the thing sold. In general, a perfected contract of sale cannot be challenged on the ground of the seller's non-ownership of the thing sold at the time of the perfection of the contract. Because remember, say contract of sale is perfected by mere consent, right? It does not get perfected by the delivery of the thing sold, although one of the obligations of the seller is to deliver the thing sold. But our law does not require the seller's ownership at the time of the perfection of the contract. Our law, however, requires that upon delivery of the thing sold, the seller should have the right to transfer ownership of the thing sold. Okay? Liability in case of loss, when the thing subject to the sale is placed in the control and possession of the buyer or his agent, the delivery is complete and the buyer cannot avoid liability in case the thing is subsequently lost without the fault of the vendor. Right of the vendor to acclaim payment. Delivery produces its natural effects in law, the principal and most important of which being the transfer of ownership without prejudice to the right of the vendor to claim payment of the price. Siyempre, kung dineliver ko na yan, I have the right to collect the payment. Where the buyer has not become the owner of for the lack of delivery, his action is not acción reinvindicatoria but one against the vendor for specific performance or rescission, with damages in either case. Consummation of contract. Okay, so the delivery of the thing together with the payment of the price marks the consummation of the sale. Perfection of the contract, on the other hand, relates to the moment when the meeting of the minds between the parties takes place. That's why we said contracts of sales are consensual because it was perfected by mere consent, but it is consummated by the delivery and acceptance and the corresponding payment of the buyer. Enjoyment of the thing sold. Delivery is also necessary to enable the vendee to enjoy and make use of the property purchased. Okay, so when is delivery deemed made? There is actual delivery when the thing is sold, when the thing sold is placed in the control and possession of the vendee, which is the buyer or his agent. It involves the physical delivery of the thing and is usually done by passing of a movable thing from hand to hand. Okay? But it is not always essential to pass title. Okay? Actual or manual delivery of an article sold is not always essential to the passing of the title thereto. The parties to the contract may agree when and on what conditions the ownership in the subject of the contract shall pass to the buyer. Like, for example, as we've mentioned earlier, it could be stipulated that the title to the property, as specified in the contract, can only be transferred to the vendee, the buyer, upon the payment of the full amount of the contract price. Okay, so let's look at another example. Okay, a bank took possession as security of the sugar sold and delivered by unpaid seller to the buyer pledgor, who subsequently became insolvent. So let's look at the facts. S sold sugar to B. The sugar was delivered by S into B's warehouse. Okay, leaving it entirely subject to his control. B, however, failed to make payment after completion of delivery as per agreement. C, a bank took possession of the sugar pursuant to a contract of pledge entered into between the bank and B to secure the latter's indebtedness of 20,000 pesos. Subsequently, B became insolvent. Is S still the owner of the sugar as to entitle him to recovery of its possession? Okay. You have to understand that S here sold the sugar to B. Tapos si B, pinadeliver niya na dun sa warehouse, di ba? Na-deliver naman si S. Si B ngayon, hindi nakabayad. Tapos, si B pa, may utang pala sa bangko. Kinuha ng bangko ngayon yung mga sugar at ginawang collateral dahil dun may utang sa 20,000. So, nakuha ni bangko yung sugar, hindi pa nakabayad si B kay S. Si S nag-deliver na ng sugar. So, pwede bang makuha ni S? Okay, is S still the owner of the sugar as to entitle him to recovery of its possession? Anong sabi ng court? Hindi. Hindi na siya ang may-ari. When S delivered the sugar into B's warehouse, leaving it entirely subject to his control, it is difficult to see how S could have divested himself more completely of the possession of the sugar, or how he could have placed it more completely under the control of the buyer. The fact that the price has not yet been paid in the absence of stipulation was not, nor could it be an obstacle to the acquisition of ownership by B, without prejudice, of course, to the right of S to claim payment of the sum due. Ano daw? Hindi na daw may-ari si S? Ang question kasi, is S still the owner of the sugar as to entitle him to recovery of its possession? Sabi ng korte, no. When S delivered the sugar into B's warehouse, leaving it entirely subject to his control, okay? It is difficult to see how S could have divested himself more completely of the possession of the sugar, or how he could have placed it more completely under the control of the buyer. But the fact that the price has not yet been paid in the absence of stipulation was not, or could it be, an obstacle in the acquisition of the ownership by B. So since na-transfer niya na yung possession, nandun na kay B yung ownership. But S is not precluded, don't get me wrong, it's not precluded to claim the payment of the sum due. He can still go after B for the payment of the sugar. But sugar is already now in the possession of the bank, and B has actually custody and possession of the sugar at the time of the delivery, leaving it entirely subject to his control, sabi dyan sa facts. Okay? So, yeah. That's on the title and possession. Okay? Possession of the articles. Okay, exists when delivery of movable and immovable things is not actual or material but represented by other signs or acts indicative thereof. Public instrument is one which is acknowledged before notary public or any official authorized to administer oath by the person who executed the same. Okay, so execution of a public instrument or document. 1. Possession transferred to buyer by notarized deed of conveyance. And 2. Delivery presumptive only. If it appears from the document, or it can be inferred therefrom, that it was not the intention of the parties to make delivery, no tradition can be deemed to have taken place. Okay, presumptive delivery by execution of public instrument can also be negated by failure of the vendee to take material possession of the land subject to the sale in the concept of purchaser owner. So when the thing not subject to control of vendor, a seller cannot deliver constructively if he cannot deliver actually, even if he wants to. If you cannot deliver it actually, you cannot deliver it constructively. That's just what it means. The delivery of the movable property may likewise be made by mere consent or agreement of the contracting parties if the thing sold cannot be transferred to the possession of the vendee at the time of the sale, or if the latter already had it in his possession for any other reason. Okay. Okay. So these are Traditio Longa Mano, Brevi Mano, and Constitutum Possessorio. So in Traditio Longa Mano, it takes place by the mere consent or agreement of the contracting parties, as when the vendor merely points to the thing sold, which shall thereafter be at the control and disposal of the vendee. So point lang niya, ayan yan, longa mano. Okay, long hand. That's the thing sold. Brevi mano, when the vendee has already the possession of the thing sold by virtue of another title, as when the lessor sells the thing leased to the lessee. So ito, example is the delivery is already delivery is traditio brevi mano because the buyer already has the possession of the thing sold. Example, hiniram mo yung gamit, okay? Tapos sabi mo, bilhin ko na lang. So there is no longer delivery kasi nasa iyo na yung possession. So the delivery is traditio brevi mano. Traditio constitutum possessorium, it takes place when the vendor continues in possession of the property sold as owner but in some other capacity, as for example, when the vendor stays as a tenant at the vendee. So in this case, baliktad. Si seller is still in possession of the property or the thing sold and is not turning over it to the buyer, okay, because he's renting it out. So, parang sabi niya, oh, benta ko yung car ko, pero hindi ko muna siya ibibigay sa'yo. Irerentahan ko lang sa'yo. So, you pay me, say, for example, 900,000 pesos for my car, and then I will rent it from you. Okay, babayad ako ng 3,000 pesos per day. I will have to use it for 5 days. Ganon. So, that is traditio constitutum possessorio. Possession. It constitutes possession, okay, in the on the part of the vendor. Okay, so these are the three kinds of traditio. Traditio longa mano is when the vendor merely points to the thing sold which shall thereafter be at the control and disposal of the vendee. Okay, while traditio brevi mano, you are already in possession of the buyer already has the possession of the thing sold and purchased. Traditio constitutum possessorium, the vendor retains the possession. Okay, so traditio constitutum possessorium retains the possession of the thing sold. Traditio brevi mano, the buyer already has possession of the thing sold. Traditio longa mano, okay, it is when the thing sold is just pointed out that it's the thing sold and the buyer can already take possession and take control and at his disposal the thing sold. Okay, so longa mano, brevi mano, and constitutum possessorium. With respect to incorporeal property, the provisions of the first paragraph of Article 1498 shall govern. In any other case wherein said provisions are not applicable, the placing of the titles of the ownership in the possession of the vendee or the use by the vendee of his rights with the vendor's consent shall be understood as a delivery. Okay. What is quasi-traditio or quasi-delivery? Tradition can only be made with respect to corporeal things. In case of incorporeal things, delivery is effected by the execution of a public instrument, by the placing of the titles of ownership in the possession of the vendee, or by allowing the vendee to use his rights as a new owner with the consent of the vendor. Thus, the delivery to a person of a negotiable document of title in which it is stated that the goods referred to therein will be delivered to the bearer amounts to delivery of the goods to such person. Okay, so contracts of sale or return and sale on trial or approval of or satisfaction. Okay. Okay. Just a bit. Mm-hmm. Okay, so sale or return. The buyer has an option to purchase or return the same to the seller instead of paying the price without reference to the quality of goods. Okay, the buyer has an option to purchase that if the goods prove satisfactory. The title shall continue in the seller until the sale has become absolute either by the buyer's approval of the goods or by his filing or to comply with the express or implied conditions of the contract as to giving notice of dissatisfaction. So kung sale on trial or approval, the buyer has an option to purchase the goods if the goods prove satisfactory. In sale or return, the buyer has an option to purchase or return the same to the seller instead of paying the price. Okay, sale or return distinguished from sale on trial. In sale on return, subject to resolutory condition. Sale on trial, subject to suspensive condition. And in the sale or return, it depends entirely on the will of the buyer. Okay, if he decides to buy, then hindi niya na i-susolid. If they decided to return, susolid niya. Sale on trial depends on the character or quality of the goods. Okay? Big sabihin, pag hindi siya satisfied dahil nga on trial, he can choose not to buy. The ownership of the goods in the sale or return passes to the buyer on delivery, and subsequent return of the goods reverts the ownership to the seller. While in sale on trial, the ownership remains with the seller until the buyer signifies his approval or acceptance of the to the seller. Okay? So pag sinabi niya, okay, satisfied, approved, then the ownership is going to be transferred to the buyer. Okay, but even if there is already actual physical possession by the buyer of the thing in the sale on trial, it does not transfer ownership to the buyer until the buyer signifies his approval or acceptance. In the sale or return, the risk of loss or injury rests upon the buyer, while in the sale on trial, the risk still remains with the seller. Okay? Okay. Shall. Okay. So, in sale or return is distinguished from sale on trial. Delivery of specific goods or sold generally passes title. Okay. Delivery to a carrier. So, general rule, the delivery be it only constructive, and the delivery to the carrier is deemed to be delivery to the buyer. Okay, kasi transit na siya. Redelivering by carrier to himself. If the seller directs the carrier to redeliver the goods at their destination to the seller himself or to his order, the ownership still remains in the latter. Wala siyang transfer of ownership yet kasi meron siyang recourse, okay, at the option of the seller. I can do this. Okay. So, when carrier becomes bailey for seller, where goods are shipped and by the bill of lading, the goods are deliverable to the seller or his agent, or to the order of the seller or his agent, the seller thereby reserves the ownership of the goods. And the rights of the seller may not only retain the goods until the buyer performs his obligation under contract. Okay, were the seller's title only for purpose of security? Okay, so here, form of bill of lading not conclusive. The circumstances may be such that were it not for the form of the bill of lading, the ownership would have passed to the buyer on shipment of the goods. The seller reserves ownership is simply to secure himself in regard to the performance by the buyer of the latter's obligation. So, dapat muna magbayad si buyer para ma-transfer sa kanya yung ownership. So, the seller is titled only for the purpose of security, meaning he's not transferring the ownership entirely. Where ownership would have passed but for the form of bill of lading. By shipping the goods, the seller has definitely lost all use of them to the buyer. Where the title to the goods is held merely for the purpose of security, the beneficial owner, meaning the buyer, not the one who holds the security or seller, bears the risk of loss or deterioration upon shipment. Although in this case, only in the form of the bill of lading, the seller still bears ownership as security. Okay. So where the buyer or his agent is consigning, but the seller retains the bill of lading. What does it mean? The seller thereby retains a right to the possession of the goods as against the buyer. Although the property in the goods will ordinarily pass to the buyer on delivery, the latter is unable to obtain the goods without the bill. Here, the seller retains the bill of lading. Sigurista talaga si seller dito. Okay, he will not release without the bill of lading, and he will not release the bill of lading if there is no payment from the buyer. Where the bill of lading is sent forward with draft attached, the fact that the bill of lading and bill of exchange are attached together indicates that the seller intends to make the delivery of the goods conditional upon the payment or acceptance of the draft. Okay, meron siyang pinanghahawakang draft or meron talagang payment. Effect of buyers obtaining possession of bill of lading without honoring draft. A purchaser in good faith for value of the bill of lading or goods from the buyer will obtain the ownership of the goods, although the bill of exchange has not been honored. Okay, so what are the risks of loss generally? Okay, a tense title. Generally, if the thing is lost by fortuitous event, the risk is borne by the owner of the thing at the time of the loss, except when the ownership is considered transferred to the buyer, who therefore assumes the risk from the time of the delivery. That's the inventory in relation to your accounting. Medyo familiar kayo dapat dito nung sinabing FOB destination or FOB shipping point. Okay, who owns the inventory or who owns the items? So whoever owns should bear the risk of loss. The ownership is considered transferred to the buyer, who therefore assumes the risk of the time of the delivery if it's shipping point, no? Where the actual delivery has been delayed through the fault of either the buyer or the seller. In this case, the law punishes the party at fault. Kung sino yung at fault, siya yung may loss. Okay, what is the risk of loss by fortuitous event after perfection? Okay, if the thing is lost after perfection of the contract, but before its delivery, even before the ownership is transferred to the buyer, the risk of loss by a fortuitous event without the seller's fault, okay, underline yan, is borne by the buyer. Taken from the American law on sales, it provides that unless otherwise agreed, the goods remain at the seller's risk until the ownership therein is transferred to the buyer. The risk of loss is shifted from the seller to the buyer, even though the buyer has not yet acquired ownership thereof. This conflict can only be resolved by legislation. Okay. So about the sale by the person, not the owner. Pwede ba yan? Yes. So where the owner of the goods is, by his conduct, precluded from denying the seller's authority to sell. Where a property is sold by one, not the owner or the agent of the owner, but the real owner states that he authorizes such sale so that the vendor was acquitted of the charge against him, a buyer in good faith acquires a valid title to the property, as it is not lawful nor permissible for said owner to deny or retract his former sworn statement that he had consented to the sale. Kung sinabi niya na he consented to the sale, he is stooped, okay? by his statement, he is stooped to claim otherwise. Okay, so where the law enables the apparent owner to dispose of the goods as if he were the true owner thereof, has no such law as the Factors Act. Okay. Sorry, guys. Someone is messaging. Okay. So where the law enables the apparent owner to dispose of the goods as if he were the true owner thereof, has no such law as the Factors Act. The law referred to here, therefore, must be found in the provisions of Civil Code on agency, which is another topic. Okay. Where the sale is sanctioned by statutory or judicial authority, it's the one who has lost any movable or has been unlawfully deprived thereof may recover it from the person in possession of the same. If the possessor of a movable lost or of which the owner has unlawfully been deprived has acquired it in good faith at a public sale, the owner cannot obtain its return without reimbursing the price paid therefor. Did you get this? So, kung nawala mo yung gamit mo, nakita mo siya in possession of another person, hindi mo siya basta-basta kunin lang. Especially if it was acquired by the new possessor, okay, of the movable lost through a public sale and in good faith. Pwede mo siyang kunin pero kailangan mo siyang bayaran for the cost that he has paid. Okay? Where the sale is made at merchant stores, fairs, or markets. The rule is necessary not only to facilitate commercial sales of movables, but also to give stability to business transactions, especially in our country, where free enterprise prevails for a buyer. Okay? So, ito kasi mga sales not by the owner to ha. So, yung number 3, nawala yung gamit, found by someone else, maybe with it, the new possessor actually bought it in good faith at a public sale, so he has no idea at all that it's not the owner who's selling it because it's a public sale. Okay? 4, the rule is necessary that merchant stores, fairs, or markets. So, as long as it's sold in stores, fairs, or markets, you do not ask them, ikaw ba talaga may-ari nito? Kaya ka nagbibenta nito? No, bibili ka lang, di ba? So, that's covered under Article 1505. Where the seller has a voidable title which has not been voided at the time of sale, okay, and where the seller subsequently acquires title. When a person conveys property to another of which at the time he is not the owner, his subsequent acquisition of the title validates his previous conveyance. Parang na-ratify lang niya. Okay? So, sale by one having a voidable title. Kung hindi pa sila talaga totally owner. Okay? If the seller has only a voidable title to the goods, the buyer acquires a good title to the goods provided he buys them before the title of the seller has been avoided in good faith and without notice of the seller's defect of title. Yung wala kang kaalam-alam na hindi pa talaga siya talaga totally may-ari. And before pa na-void yung title niya, nabili mo na siya in good faith at wala kang alam na merong problema yung title niya over the thing sold. Basis for the rule seems to be based on the principle that where loss has happened, which must fall on one of two innocent persons, it should be borne by him who is the occasion of the loss. Okay. S, a minor, sold his television set to B, a person of majority age. Under the law, the contract is voidable or annullable because minor Okay? Under the law, the contract is voidable or annullable because a minor is incapable of giving consent to a contract. B, in turn, sold the television set to C, who acted in good faith. So, galing kay S, minor, binenta niya kay B. Tapos si B, binenta niya kay C. Si S, minor. Si B, okay lang siya, okay, of legal age. In this case, C acquires a valid title to the television set after its delivery if the contract had not yet been annulled by a proper action in court. Dahil wala namang alam si C, in good faith. Okay, 2. B bought in good faith for value a car which was stolen by C. Nakaw, the lawful owner. Okay? As against B, C has a better right to the car. Okay? Si B binili niya in good faith for value a car which was stolen from C. Si C ang may-ari, ninakaw lang sa kanya yon. Pero si B nabili niya kay in good faith. As against B, C has a better right to the car. Article 1506 is clearly inapplicable where the seller had no title at all. So kung nakaw, there is no title at all. Hindi siya voidable na title. Wala talaga siyang title to the car. So it is C who has a better title to the car. C may recover the car without paying any indemnity except when B acquired in a public sale. Mag-iiba daw yung storya kung yung pag-acquire ni B ng sasakyan is galing sa like public sale, yung display talaga ng mga sasakyan, kasama yun na display yung ninakaw na sasakyan niya. Malay ba ni B? Okay? So it's a different story. But if B just bought it from someone else and not, okay, even if in good faith, because wala siyang knowledge na nakaw pala yun, C still has a better title over B. Okay? Next, nature and function of documents of title. So, receipts of or orders upon a bailee of goods represented. Documents of title refer to goods and not to money. So, a different name is given in popular speech to the document when it is issued by a carrier and it is issued by a warehouseman. Okay. Evidence of transfer of title and possession of goods and contract between the parties. Could be a document of title is a symbol of goods by it, covered by it, serving as evidence of 1. Transfer of title, 2. Transfer of possession, and 3. Contract between the parties who are bound by its terms. What are the most common forms of documents? Bill of lading, doc warrant, warehouse receipt, and kidan. Okay? Bill of lading, it is a contract or receipt for the transport of goods and their delivery to the person named therein to order or to the bearer. It usually involves 3 persons, the carrier, the shipper, and the consignee. The shipper and the consignee may be one and the same person. Okay? Dock warrant, an instrument given by dock owners to an importer of goods warehoused on the dock recognizing the importer's title to the said goods. Warehouse receipt, ito yung sa warehouse man. Diba? It is a contract or receipt for goods deposited with the warehouse man containing the latter's undertaking to hold and deliver the said goods to a specified person to order or to bear. Okay, you may be familiar with this. Are you done with your negotiable instruments already? Law on negotiable instruments? Okay, classes of documents of title. Negotiable documents, those by the terms of which the bailee undertakes to deliver the goods to the bearer and to the order of a specified person. Non-negotiable documents, those by the terms of which the goods covered are deliverable to a specified person. So, mag-iiba lang yung negotiability because of the word to the order or to goods to the bearer and to the order. Ito kasi specified person. That's why I asked if you are done with negotiable instruments because you'll have a better perspective and understanding of this one if you've actually covered negotiable instruments. Okay. So negotiation of negotiable documents. Mm, okay. Flaw dito sa okay. Okay. Just take some 5 minutes break for now.